Good morning, everyone, and welcome to Unlocking the Hidden Value of the Real Estate Underneath Your Business Facility. I'm Vinny Civitello, Communications Manager for the New Jersey Business and Industry Association. With us today are Jason Sobel of Sills, Cummins & Gross, George Jacobs of Jacobs Enterprises, and Daniel Prashada of Prisco Financial. A few housekeeping matters before we get started. Today's webinar is being recorded and will be emailed to you tomorrow along with the PowerPoint for today's presentation, so be on the lookout for those. If you can't wait for that email, you can download the PowerPoint right now in the Handouts tab of your GoToWebinar panel. I'd also like to draw your attention to the Questions tab. Jason, George, and Dan would be happy to take all of your questions, so don't hesitate to write them in as they come to you. And I can't stress that enough. Write them in as they come to you, or you might forget what you wanted to know by the time we hit the Q&A. So before we get started, I'd just like to take a minute to tell you a little bit about our speakers today. So Jason Sobel is of counsel to the Sills, Cummins & Gross Real Estate Department and focuses on all aspects of commercial real estate transactions, including development, leasing, and financing. He represents several leading institutions in commercial and construction financing, as well as numerous commercial real estate owners and businesses. Jason primarily counsels commercial and residential real estate owners and developers regarding acquisition, sales, financing, leasing, and development projects. He also represents clients on a number of business law and contract-related matters affecting their daily activities. He assists various types of businesses with respect to their contract negotiations and drafting, interactions with third-party vendors, taxation-related matters, and new entity formation. Over the last several years, Jason has represented clients in deals that NAIOP New Jersey recognized as Deal of the Year finalists. George Jacobs has been active in the real estate industry since 1974, including serving as a principal with Hartz Mountain Industries during the 1980s, where he was active in the development of over 20 million square feet. He founded Jacobs Enterprises in 1990 and is an active developer, consultant, and broker in a wide variety of projects throughout the metropolitan New York area. He is also managing member of a 100 million plus acquisition and development fund. Additionally, his management company, JK Management, manages more than 1 million square feet of retail and commercial space and 400 apartments. Over the years, he has served on the boards of numerous organizations and trade groups. And finally, Dan Prashada, with 30 years of financial, business, and succession and real estate preservation planning experience, delivers a superior level of commitment and expertise to his clients. Having worked on more than 3,000 cases, his knowledge of the financial and business planning process enables him to explore multiple design scenarios before presenting the appropriate client-tailored options. After gaining experience as a CPA with PricewaterhouseCoopers, Dan started his financial advisory practice, Prisco Financial. Dan is also the founder of Equity Strategies Group, a platform for M&A and investment banking, and the Business Intelligence Institute to help business owners grow and protect their business and real estate interests. Dan is a sought-after speaker on the topics of business exit strategies, financial and estate planning, and has presented at numerous industry and association events. He has been interviewed by CNN Business News, WFAS Financial Radio, and quoted in the Wall Street Journal, LA Times, and Fortune Small Business. Dan is the author of the highly acclaimed books Defend Your Wealth and One Way Out. He is a magna cum laude graduate of Fairleigh Dickinson University with a BS degree in accounting. So now let's get things started. Jason?
So the FOR group takes a multidisciplinary approach, myself being the attorney, George playing the developer role, and Dan with the financial advisor role. And we work with closely held businesses regarding their real estate issues. Today's program is going to work basically on two prongs. Our first scenario is a static situation with respect to real estate. This is where all's good with the business situation and there's no real compelling reason to do anything with the business real estate assets. And our second scenario, which we'll go into later, is our fluid scenario, which is where there's some compelling reason for the business to take action with respect to its real estate. So when dealing with our first situation, why are changes to be considered? Since all's fine with the real estate, why would you want to rock the boat? And one reason is diversification. However, when you're diversifying, the problem really would be that you need cash, but you don't want to sell your real estate. In that instance, the owners can take a mortgage on their existing property and typically get about 65 to 75% of the appraised value of the real estate in cash. There are no tax consequences here, but the owner needs to be careful if the lender wants to secure the business assets as well as or get a personal guarantee from the owners. This is considered a recourse loan. A non-recourse loan is where only the real estate secures the debt as collateral, as opposed to these other assets or guarantees. They typically have higher interest rates on a non-recourse loan, and we do want to really go as a real estate owner with a non-recourse loan as opposed to a recourse loan, because you'd like to avoid putting up that additional collateral.
Hi, this is George Jacobs speaking.
One of the issues that we have with lenders are not every lender works for every borrower's need. So you ought to be concerned or sensitive to that issue. The small banks that you've perhaps been working with up until now to finance your business also have real estate lending capacity. But if it is a small bank, it's not typically in that business on a non-recourse basis. So not every lender is going to work for every need.
Your second problem may be that you want to free up capital, but you still need the property. And one of the solutions to that is a sale-leaseback. A sale-leaseback is pretty popular these days. We see them all the time. It's the sale of the property which is made simultaneously with the lease back to the seller or the original owner. The term could be long to ensure continuity with the ongoing business. You can even have a long term with a number of different renewal terms to make sure that if there's flexibility with the business, or to preserve your flexibility with the business, so that if you don't need the full term or you want to have a longer term, you have some flexibility on adding on years at the end. The buyer could be a REIT or a group from a family that wants to retain the real property asset.
It's also a way of freeing up capital to unrelated parties. We had a situation with a major bank that owned a building that it was using as its branch, but the building was 24,000 feet and a branch can go from 1,800 to 3,000 feet. In this particular case, the entire first floor of about 7,000 feet was being used as a branch. So it really didn't fit their profile anymore, but they didn't want to give up the space either. So what they did is they sold the building to us as an investment group. They did a lease back to us where they were the tenant of the first floor, and we took on responsibility for the rest of the building. This way, the bank was able to get the cost of the capital off of their books. We placed a loan with a different bank because the first bank didn't want to have a conflict between its lending and its operations. And they paid us rent. We were able to finance the property, and everybody actually did pretty well. But that's how a sale-leaseback could work. Dan, there's a lot of real estate that gets trapped inside of companies altogether. Is that right?
It sure does. And it's a very common problem working with business owners. Back in the day when they acquired the real estate, maybe they didn't do their homework, or there are other reasons whereby the corporation bought the real estate, and now they look and it's really tax trapped inside that corporation. So one of the solutions is a spin out. And, over the years when we've looked at spin outs, the tax bill was always onerous. And people are still debating how to get that real estate out. Now, under prior administration, the prior tax law, corporations were taxed at 35%. As many of our listeners are aware, the new tax law has reduced the tax rate down to 21%. So there's an opportunity to lock in a lower tax and then allow all future appreciation to grow outside of the corporate entity and avoid that double tax. You could also step up your basis and increase depreciation deductions. So now is an opportune time to really re-examine those lifetime spin-outs or rollouts of real estate from corporations.
So another reason to rock the boat would be because your real estate is currently saddled with some debt. And in this situation, the real estate is encumbered by a mortgage, and the owners realize that maybe there's more equity that could be freed up due to an appreciation of the value of that real estate. The owners may also realize that the terms of their current mortgage are no longer market or competitive, and they can get better rates. Sometimes the business grows and now has need for capital that can't be provided by the existing bank. So you need to find a new lender that can service your bigger and expanding business needs, sort of what George alluded to. Another reason to refinance may be to get one of the original guarantors on a recourse loan released from their personal guarantee. This could be instrumental in succession planning for your business, since it will also allow the initial guarantors to go on to retirement without being strapped with the debt on the property that he or she will no longer own or be receiving the benefits from. Our liquidity can be looked at in two different scenarios, a lifetime and a death, and during your lifetime and upon death or in anticipation of. And when it comes to the lifetime, there's an issue. When you sell your property during your lifetime, you could have to deal with capital gains tax. And when you have that capital gains tax, one way to avoid it is to potentially enter into a 1031 exchange. And in that scenario, it's an IRS code that provides for this type of transfer, which would avoid the tax gains, and it allows for the seller to defer any gains on a like-kind property if a like-kind property is purchased with the proceeds of sale. So you're going from real estate into real estate. And currently, it is actually only limited to real property as per the new tax code. It used to be allowed for other assets, but it's now limited to just real property under the new tax code. There is an exciting new legislation that's coming out. And we can get into this on at a later date or on another topic, but the opportunity zones legislation, which is included in the new tax code, is something that's sort of a super 1031, but we'll just use that as a teaser for later. The basic guidelines, though, for the 1031 are that the taxpayer must identify the property to be exchanged before closing. So the property you're going to be purchasing has to be identified before closing. The taxpayer must then identify the property. Sorry, I apologize. The taxpayer must identify the property to be exchanged before closing. The property you're going to sell has to be known before closing. This is known as the relinquished property. The taxpayer then has to identify the property to be purchased, which is known as the replacement property, within 45 days of closing on the sale of the relinquished property. The taxpayer then has to close on the purchase of the replacement property within 180 days of closing on the sale of that relinquished property. The taxpayer also cannot touch the proceeds of the sale from the relinquished property, or it's deemed tainted, and then it wouldn't be eligible for a tax-free exchange. So in order to avoid touching that money, the taxpayer uses a qualified intermediary, usually a bank, a title company, or a brokerage firm, to hold the money from the sale in a special account and to use those same monies for the purchase of the replacement property. Now we'll actually pass it over to Dan to talk about the issues that we deal with upon death.
Yes, Jason. So what we often find is that business owners who also have their real estate tied into the business consider the real estate to be somewhat passive. And other times the real estate is rather intense and requires active management. And a surviving spouse who receives it when a partner dies is often unable or unwilling to manage that property. Furthermore, the surviving business partners may feel somewhat encumbered by having that spouse of a divorced partner involved. So often the answer is some type of a buy-sell agreement, which basically says that upon the passing of one of the owners, the surviving owners or the business itself would buy back those shares. And the buy-sell should cover not only the business interest to be bought back, but oftentimes the business real estate as well. Now, George, you've run into scenarios where the real estate has passed to multiple parties, not just surviving spouses, but children and nieces and nephews, right?
I heard a long time ago a little phrase that says the real estate does not know who owns it. And it survives businesses, it survives families, and when it makes a transition, there's frequently a problem. We've had situations where there are cousins into the fourth or fifth generation. We're going to talk about a couple of those experiences later on. We've had companies where the real estate is retained, although the business itself has been sold. And in each and every case, the underlying problem is real estate is a industry in and of itself with a lot of intricacies that Jason has been talking about somewhat. And 1031 is one of those items. How do you unlock the value when a partner wants to sell and another doesn't want to sell? How do you lease the property? How do you finance the property? These are all issues that experienced real estate pros deal with every day, where those of you who are making a transition may not be.
Yeah, so George, you did talk about the problem of to sell or not to sell, where one partner in the real estate, we'll assume we have two partners, wants to sell and the other doesn't. If your partnership's structured properly, then it probably includes a buy-sell provision. If not, then you could run into a problem, because if one partner wants to sell the real estate but the other does not, it's how do you solve that problem? You're at odds. So there are different solutions for that situation, and typically what you would do is you could set up an entity for ownership of the property through a tenants in common agreement, or a TIC agreement. Here, each party owns an undivided fractional interest in the property, such as 50% of an entire parcel. However, even though ownership is in the entire parcel, as opposed to the northern half, the southern half, the western half, the eastern half, or some other division, the interest can be sold to a third party, and you get an interest in the entire property, and that party that's purchasing the interest becomes a tenant in common with the other percentage owners. So for example, if George and I were partners in a property, we would each own 50% of the whole. If I wanted to sell to somebody, George would then become a partner with that person that I sold to. George's interest would not be affected, and both parties, the new party that I sold to and George, would own the whole 50-50. Another tool that can be used would be to set up an LLC or partnership agreement with a put-call provision. This would allow for a buy-sell scenario to ensure that partners can exit from the real estate investment without unwinding the entire ownership. Basically, if one party makes an offer to the other party to sell his interest, and the other party doesn't want to buy on the terms offer, then the selling party can buy out the non-selling party on the same terms. So let me go through a little example here. So let's say George and I, again, are partners in a property, and we have a put-call provision in our LLC operating agreement, or our partnership agreement, and I want to exit. So I say to George, George, why don't you buy my half of the property for $1 million? If George thinks that's a good deal, he'll go ahead and do that. If I've overvalued my piece, because it's really maybe only worth $500,000, George is going to say, no, thank you, Jason. I don't want your half for $1 million. You buy me out for $1 million. And George puts that deal to me, and I am now forced to buy George out for that $1 million price. So I have to be very careful when I have that put call provision to make sure that I make a fair offer to my partner.
I want to add that there are tax implications to every one of these strategies. Converting to a TIC, you have to be careful that you don't have a step up in basis. You have to be careful that you don't trigger a mortgage transfer tax with the state of New Jersey. So you really do need counsel that does this all the time. And I'm selling for you, Jason. Okay, Dan.
And speaking of taxes, there's one final tax to consider, which is the estate tax at death. And this is the classic problem that we encounter all the time. Most business owners and real estate owners whom we work with, by design, their estates are illiquid. They're very comfortable reinvesting back into their business and reinvesting in real estate properties. And when they pass on, this creates a significant liquidity need that needs to be dealt with. Now, part of it is, let's put in place the right wealth preservation techniques, which we'll be speaking about a little bit later in the program, and try to minimize that tax to the extent possible. But where, the owners just become so successful in terms of business values, real estate values, we do need to create liquidity to deal with that remaining unavoidable tax. Jason?
Oh, I'm going to move to the next slide. Oh, I'm sorry. Yes. So sometimes we've already talked about this a little bit with our recourse and non-recourse loans, but the bottom line is that sometimes with your debt, your lender is not the right lender. So you do need to take advantage of that refinance or secondary financing in order to either obtain the extra financing that you may need to service your new business needs. But what we are finding is businesses that are expanding are finding new lenders, bigger lenders, and they're using their business assets to secure bigger loans and help their expansion of their business. But the real estate is securing that asset. The real estate is securing that financing.
Okay, so I'm going to kind of challenge the audience a little bit here in terms of we've given a lot of information regarding the three issues that confront a lot of real estate owners. That is diversification, liquidity, and debt. So, you know, the rhetorical question is, have you considered and planned for these issues? Do your successors know what to do? In other words, your spouse, your children, your CFO, do they know which properties to keep or sell? If you have multiple properties, we usually look at them as, you know, your A, B, and C assets. The A are the jewels. Those are the ones you want to hold on to. The B, those are good properties as well. You've gotten good returns, tenants, leases are strong. And C are sometimes referred to as the dogs that might get cleared out, you know, in certain situations. And finally, this is an opportune time to re-examine your real estate holdings and how they're structured under the new tax law. As you may be aware, a brand new sweeping tax law was recently signed at the end of 2017, goes into effect for 2018 and beyond. It's actually the most sweeping legislative change in the tax arena in the last 30 years. And the outcome is lower personal and corporate rates. It's really a business tax cut. And what I'm seeing is it's really favoring corporations and pass-through entities such as LLCs and partnerships. In fact, many individuals, particularly in our state of New Jersey, are finding that they're paying higher income taxes. The cost to the government is about $1.5 trillion in lost revenue. We're also seeing a higher estate and gift tax exemption, which opens up the window to a tremendous amount of wealth transfer planning to avoid taxes. Again, we'll get into that in some future slides.
So now we're going to move on to our scenario 2, the fluid situation. And again, this is where something has happened to the real estate, or there's a need to do something with the real estate because of changed circumstances. This is in contrast to the static situation that we spoke about before. As you'll see on above our dotted line on your screen, the first three issues where the property is owned by the family and their business is going out of business, there may be no succession plan, or there's a retirement, a change in health, or a death in the family. They were already discussed under our static situation, so those concepts would apply. However, some new situations that fall under our fluid situation would be expansion needs. Your business has outgrown its current building, so now the facility is not going to work for you. You need to move, and you need to add your current office. You need to add to your current office or facility, so you have to do something with your real estate. Or maybe your real estate's being underutilized. Part of the property is vacant, or it's not being used to its fullest potential. Also, you could need a reduction of space because the costs of upkeep are increasing, and it's just getting too expensive to maintain your very large facility when you really don't need something so big. You could also have your mortgage term is over. Your current financing, it's up for a refinance. You can possibly refinance. Maybe you don't need that debt anymore. You have enough cash, so you could do nothing. And sometimes your facility may become functionally obsolete. There could be changes in technology which now don't fit into your current facility. Maybe there's an example of something like you need a higher ceiling height, and your current building can't be raised, or the ceilings can't be raised, so you need to move in order to create room for that ceiling clearance, to have the proper racking and proper logistics mechanicals in your facility. Now, when dealing with transferring, sometimes you run into some roadblocks, and here's 4 of the most common that we come across. The first being environmental. If you have issues, environmental issues, you as the property owner are actually required to clean up your site. The state of New Jersey holds you responsible as a property owner for any contamination that's on your site. In that case, you're going to need to engage professionals. You may want to conduct a phase 1 environmental study, which, if that shows problems, may lead to a phase 2 environmental study. But all in all, you'll need to comply with federal and state laws. And depending on the type of business that you have, you may be subject to the Industrial Site Recovery Act, which is New Jersey's main environmental law.
You have to be very careful, because the sheer act of investigating your environmental circumstances may require a report to the state. Excuse me. The underground tank law requires the contractor or the engineer who finds it to make a report to the state, and that's accompanied with criminal liability as well as civil. The licensed site remediation professional, which was a program that was created under the auspices of DEP, New Jersey Department of Environmental Protection, which has streamlined the remediation process, also places the engineer under responsibility to report in certain circumstances. So a lot of folks who own the real estate in their business are very nervous about bringing the situation to the attention of the authorities. There's no quick cure to that. Jason?
Another issue that we deal with is your existing financing or mortgage, which becomes a barrier to your transfer of the property. There may actually be a due on sale clause, which if you sell your property, you have to now pay off the loan. And the issue could be that you won't have enough cash then to relocate by paying off the loan. So you need to plan for this and make sure you know what your current financing situation is and how much money is going to be required to pay off before you think about transferring your property. Another issue could be existing zoning. The existing property may not, or the existing zoning for the local municipality or the state, it may not allow for development, and that could potentially stop you from selling to another user. So what my firm typically does, and our 4 group, is we can help get a zone change or possibly a redevelopment agreement for your property, and that would allow for development for a better and higher use. You may want to go and get the approvals yourself before selling. Increase the property value, because you're the fair-haired boy, for lack of a better term. You're the business owner that's been in the town for the last few generations, and you know everybody, and you may even know the planning board or the zoning board. And as opposed to a new big bad developer coming in, you're well-liked and respected. So you can increase the value of your property before sale by getting some sort of zone change or getting zoning to a more advantageous type. And then you could even possibly joint venture with the developer as opposed to selling the property outright. And if you joint venture, you retain an interest in the property, and you may be able to then actually preserve that income or that value for your future generations.
We had a situation in Essex County where the industrial company that owned the real estate no longer needed to use the warehouse located on that property. We came in firstly as advisors and then as joint venture partners to evaluate the value if the warehouse was knocked down and replaced, in this case with a multifamily project. We were able to do that, and everybody did very well in the endeavor. One thing I did want to point out, Jason, on the environmental situation is if you've owned your property for a long time, you may have an asset that you're not even aware of, which is your old insurance policies. New insurance policies on property typically exclude environmental remediation as a covered cost. Many of the older policies that were written 20, 30 years ago, they didn't exclude that. We have a situation right now in Newark where a property owner has a situation where the property was polluted, but they were able to go back to some of their old policies and found that they did have coverage, which ended up being a lifesaver in the redeployment of that real estate asset. We're engaged in that effort even as we speak.
And the final barrier to transferability can be something we spoke about before, which are the tax consequences. So if you don't have a 1031, you may have taxable gains. But as I alluded to before, there is this exciting new legislation in the new tax law which provides for opportunity zones. This is actually an alternative to a 1031 exchange. It's sort of what we call a super 1031, because it would allow a property seller to put the gains from its sale into an opportunity fund, and they avoid paying gains on those paying taxes on those gains. The funds are invested in development projects in areas in need of new development. Those areas are known as opportunity zones. A preliminary list of these areas is being developed. New Jersey has their list out, Pennsylvania has their list out, and I believe New York does as well. And you could find those lists as they are developing. But another potential provision of this new legislation is that the money is kept in the opportunity fund for more than 10 years. If it's kept for more than 10 years, all gains will become tax-free. The legislation is still developing, but it's truly a potential game changer in real estate development and a great avenue for taxpayers and real estate sellers to avoid capital gains taxes when they do sell.
Okay, we wanted to give you some case studies that are projects we've worked on over the years where transition issues have unlocked the value of the real estate. In some cases for the existing owners, in other cases for new parties coming in. So we have, I think, 6 case studies that we can talk about that go to some of these particular issues. The first one is Livingston Town Center. This location was well, it still is, I guess, the heart of Livingston at Main and Main, but it had been acquired by a particular family back in 1919. By the time 1999 and 2000 came around, there were 35 cousins, many of whom didn't know each other, who owned the real estate. There was a pollution problem from a neighboring gas station. There was a concern about a dry cleaner that had been on the site at one point. There was of the 12 acres, 7 acres were forested, but the forest was not maintained, and it had become a hangout for the kids in town. The real estate itself, the buildings were mostly retail with some office space and an old movie theater, but they had been allowed to deteriorate because the cousins couldn't agree on what to do. Ultimately, the town took a fairly dramatic step and it condemned the property under an eminent domain action. And the property got into 15 years worth of litigation. Ultimately, the owning family put out a bid, an RFP, a request for proposals, that a group that we were part of won. But what we did with the family is they were not sure they wanted to sell. They may have wanted to become a partner. So the way the contract was worded was up until 10 days following the approval for the redevelopment plan, the family had the option of contributing the property into a new joint venture at a stated value, or taking and owning a third of the going forward value, or taking cash. Ultimately, they took cash, as it turned out. This property became a $150 million redevelopment project that we were fortunate enough to be partners of, and that's the redeployment of the real estate. The family that was unable to unlock that value ended up selling for $10 million, and they went away happy, and we were able to develop a major project. The next project, some of you may be familiar with, is in downtown Summit. This is known as the Summit Opera House. It was owned by a particular family for about 50 or 60 years, and when the parents passed away, the remaining family members were unable to redeploy and fix the building, which was in desperate need of rehabilitation. There was a foreclosure. The family lost the property. We were able to buy the foreclosed property and pumped in, at this point, probably $500,000 to $600,000 of new capital. What we've done with it, however, is we took it from a $2 million acquisition, and property is worth today between $4 and $5 million. The restaurant Winbury's, which some of you may be familiar with, just re-entered their lease for a new 15-year term and reinvested and fixed up the property. So it has gone on to become an income-producing property with a lot of value. Tyre is a portfolio. It's a 230,000 foot shopping center, which was 200,000 feet at the time we got involved, and we did an expansion, and a complex of apartments known as Stuyertown Apartments and Maple Garden Apartments. Here, a family, again in the 30 to 40 number of persons involved, could not redeploy capital. They ended up selling to an investment group, which we were part of, and we've created a lot of value in redeploying the property, fixing up the real estate, taking the lead out of the property, taking the asbestos out of the property, and enjoying the fruits of that effort over the past 20 years. The next example was the Kanter Portfolio. Saul Kanter had put together a portfolio, much of which he had sold before he died, but then he died. He left behind a wife and 2 daughters, none of whom had been in the business. They didn't know what to do with the real estate. They didn't know how to protect themselves from some litigation. And they needed an asset manager, which we were fortunate enough to get the assignment. Of the 7 original assets that we took over, 1 was sold. The other 6 we now manage. We've created a lot of value. Our interests have been protected by fees. We're not partners in this portfolio, and the family has now got income-producing property where they had it, but they didn't know what to do with it or how to handle it, so they engaged professionals. Here's another example in downtown Ridgewood. This is a property that sits right next to the movie theater, which you can see in the background of this photograph. The property was owned by a brother and sister, or actually a family, whose father had entered into a 65-year ground lease. The father passed away, and the 65 years came up. The brother and sister, neither of whom were in the business, had been collecting $5,000 a year. We were able to come in as the asset manager. They're now making more than $300,000 a year on a net investment of not a lot of money, but again, they needed professionals to come in and show them how to do it. The final example is a large portfolio owned by a publishing company where they had about 750,000 feet of existing improvements up in Mahwah. They sold the business to an international company who no longer needed the real estate. The family retained the real estate. But they went from having 1,000 people who were able to pay attention to the real estate to 0. In this case, their attorneys introduced them to us. We came in as the asset manager, leased up the vacant property, redeployed the vacant land and sold it. And ultimately, we sold the portfolio to a real estate investment trust. Again, we weren't partners, but we were able to unlock the value. They sold this property for more than $40 million outside of the sale of the business, which reaped a lot more money on top of that. So these are examples. Not everyone may be applicable to your situation, but they show you how dealing with transition issues and dealing with the real estate needs can unlock millions and millions of dollars in untapped resources. I want to turn this over to Dan now and he'll tell you what to do with the money.
You're right, George. So, you've spent a lifetime building a successful business and/or investing in real estate. The question is, how do you keep together what you put together and then pass it on to your family after you're gone? The single largest obstacle for those with significant assets is the federal estate tax. Now, good news is Good news is that New Jersey repealed its state estate tax, hopefully never to return again. But the federal estate tax is alive and well with temporary high exemptions. So this slide just gives an overview of how the federal estate tax works. Essentially, when you're gone, there's a tax return that's filed. Your executor, typically your surviving spouse or your adult child, is going to add up everything you own and disclose it on a tax return. So business financials will be attached, real estate appraisals will be attached, and this form will be filed with the federal government, and a tax will be assessed. The tax is due in 9 months. The IRS doesn't accept brick or mortar or IOUs. They only want cash. And if your family doesn't have the liquid dollars available to pay the tax, then it's inevitable that liquidations will occur. So planning is so important. One day it'll be too late to plan, so it's important to get it started now. Now, the next slide shows a little bit of history. I'm not going to spend a lot of time on this, but there was a time when the gift and estate tax exemptions were only $1 million or $1.5 million, meaning if you passed away with a net worth in excess of those exemptions, the tax kicked in right away. Well, good news is, go to the right of the page and you see from 2018 to 2025. So for those who pass away in the next 8 years, the estate tax exemption is extraordinarily high. It's $11.2 million. For married couples, there's 2 exemptions. And if your estate and your wills are properly structured, you can pass $22.4 million estate tax exempt. However, on December 31st, 2025, the law sunsets. So you see the sun setting into the ocean there. And that's because the new tax law increases the federal deficit so much that they had to put a sunset in it after 8 years. That's just the way these laws work. So now the tax would revert back to $5.6 million of exemption. And who knows? There could be a change in the administration in Washington, and that reversion could occur even sooner. So it really is a window of opportunity. It could be open for 8 years. It could be open for 2 years. It could be open for 6 years. Who knows? But there's going to be a bonanza of activity now. As I say, use it or lose it. So if we go to the next page, you see a very overly simple diagram that really can become complex. But at its simplest form, you have your property, your real estate, and other assets on the left side of what I call the tax fence. On the right side of the fence, you have the ability to set up various family trusts. They have different names. We'll call it family trusts. And while you're alive, you can restructure, rearrange, transfer, gift assets from the taxable side of the fence over into the tax exempt side of the fence. And you can use your exemptions and exclusions to do so. And again, you look at the extraordinarily high exemptions up to $22.4 million. So no one's recommending you transfer at all, but it would certainly be wise to take advantage of this and certain discounts to move assets from the left side of the fence to the right side of the fence. It's up to you really to plan your estate so that you set it up so that the IRS gets as little as possible. And I would submit if you haven't transferred assets over the tax fence, then the IRS is probably getting too much. And you can set it up in ways where you can still retain access control and also to certain levels of income. This continuum on this page really looks to all of the different techniques. Obviously, we're not going to be able to spend enough time on today's program, but I kind of laid it out from basic to advanced. And it's not just what you know about these techniques, it's what you do with these techniques. It's all about execution. So on the basic side, on the left side of the slide, you can use your annual exclusion gifts to transfer real estate or any other asset, closely held business interests. And it was one time, $10,000 a year gift. It's now indexed, it's $15,000. Husband and wife can give away $30,000 times the number of beneficiaries. So if mom and dad have 3 children, they can give away $90,000 a year. Simple, yet extremely effective. Moving towards the right side of the continuum, you can use, again, a portion of your lifetime gift exemption, the $11.2 million. It could be put in various trusts such as SLATs, which is a spousal lifetime access trust. I call it having your cake and eating it too, whereby you can transfer assets out of your taxable estate into an estate tax exempt trust that's also creditor proof. So creditors and predators can't get at those assets. Future ex-spouses of children and grandchildren can't get at those assets. They're completely bulletproof and insulated. But I say have your cake and eat it too, because you can set up a spousal lifetime access trust whereby through your spouse, you can retain access, you can retain the income, you can retain the principal, you can continue to buy and sell and flip and 1031 properties inside that trust, and you can take back whatever you need to support your lifestyle. Of course, you want to keep it there, for estate planning purposes, but it's nice to know that you have the flexibility that you could always tap into those assets or the income should you ever need them. Going further on the continuum, you can sell assets to the trust. You can make loans to the trust. Further, you see the acronym soup of estate planning, as I call it. You can set up things like GRATs and CUPRTs, where, again, you can make glorified gifts and yet still retain access to the income for a period of time or for your lifetime, and get tremendous discounts on the amount of exemption that you use to make those gifts. You can do also what's known as a sale to an IDIT or a sale to the trust. So where in the larger situations where we kind of run into the upper limits of our exclusions and exemptions, you have the ability to sell assets to a trust and take back a note. By selling it, you effectively freeze the value of the asset. And since you're selling it to your own trust, there's no capital gains tax to experience. There's also a variety of charitable gifts and charitable trusts. So there are a plethora of techniques to explore. It's a question of which one of these best fits your situation, which leads into our planning process. So, FRE, family-owned real estate, as a group, George, Jason, and I, we work with closely held business owners. We work with real estate owners to help them develop and ultimately implement the right strategy for them. And you heard a lot of the strategies as Jason went through various techniques. George went through all of the examples that he's successfully helped clients with over the years. It starts with step one, discovery. It all starts with understanding your goals and objectives, your value judgment, your vision, your preferences, time frames, and so forth. Second is a document audit, reviewing all relevant documents. That includes deeds and titles and financial statements and mortgage notes and wills and trusts, and making sure that everything you've done up to this point in your life is done as well as it can be. And it also helps everyone get their arms around your current situation as a starting point, which then lends itself to step three, brainstorming. So behind the scenes, advisors like myself and Jason and George and others, we have access to the law firm, real estate developers, and as financial advisors, access to resources like M&A firms and brokers. All of this brainstorming and design takes place behind the scenes, and then results in recommendations that lead to step four, action plan. And many times we boil it down to just one page, an action list, and that enables us to stay on track, to be held accountable, and to turn ideas and strategies into reality. So that brings us really to the end of our prepared remarks. We're going to open up the lines now and see if there are any questions. Vinny, I understand people can type in questions, and we'll take any questions that you may have at this point. Thank you very much for the opportunity to share our thoughts and ideas, and we look forward to any questions you might have.
Thanks, Dan. Yeah, we do have a couple questions here already, but I want to give everyone else a moment to type in anything they have. While I'm doing that, I'd like to take a second to remind you about the handouts tab. I get a lot of questions from people about how to download the slides. So just open up the tab, mark handouts in your GoToWebinar panel, and the file is right there. You can also just wait until tomorrow, and they'll be emailed to you along with the video recording of today's webinar. And there's the questions tab. So if you have a question, type it in right there, and I'll make sure our guests answer it. And don't be shy. You've got 3 experts here, so make sure to take advantage of them. It's always really disappointing when I read the survey results for our evaluation and somebody says, I was really hoping they would touch on X. This is your opportunity to ask X. So with all that, let's jump right into our first question that comes from Pete, who asks, in one of your earlier slides, you referred to Mount Laurel. What do you mean?
This is George. I'll take a shot at that. Mount Laurel is a community in South Jersey, but it was the subject of affordable housing litigation, and it has come to refer to all affordable housing decisions and controversies in the state of New Jersey. We're in a situation where the Supreme Court of the state has indicated that there's a lack of affordable housing opportunities that in part is created by exclusionary zoning. And it's controversial. Some governors are for it, some governors are against it. Housing advocates want to expand the opportunity for affordable housing. Developers generally are not anxious to do so for selfish reasons, but we all recognize the need and the rightness of doing so. Many new projects, for example, as a shorthand, 20% of units for residential multifamily rental development are typically set aside for affordable housing. There's a lot of litigation on this. It is coming into focus. I think there's a recent Supreme Court decision that Jason perhaps can address, but that's really what we're talking about.
Yeah, well, COA is going through some changes, and it really is a fluid situation. So I think to speak about where we are with COA right now is it's not really going to help anybody because it is such a fluid situation right now.
Just keep it in mind. Usually what happens is 80% of the median income of your community is the threshold, and units have to be sort of put aside, and it's always residential. There are fees. Periodically, you get assessed in a non-residential scenario where 2 to 2.5% of the construction cost is assessed as a new development fee by the municipality. So that it is fluid, it is complicated. We're not here as particular experts on it. We hire the experts to advise us to what to do, but be aware that it is an issue out there.
Okay, our next question comes from Mary. Have you seen receivers or trustees get in the middle of any of these situations?
I've actually been designated the receiver and the trustee in a number of circumstances. The largest was the Uppsala College in East Orange, which filed bankruptcy, I believe, in 1995 or 1996. And it was a $2.5 million project or campus where the college went out of business. We were appointed by the court. I was the receiver reporting to both the court and the trustee, who was a bankruptcy attorney. And we ended up selling half of the campus to the city of East Orange for a new high school and half the campus to a residential developer where the existing buildings were demolished and I believe 35 new homes were built. The Summit Opera case study that I alluded to earlier, I was appointed the receiver of that by the bank because they had a problem with the existing debtor. So we do run into these situations a lot.
Our next one comes from Ted, who says, my brother is deceased. My sister-in-law and I own a parcel on which a family business had been operated. How do I first deal with a recalcitrant in-law when we have no written agreements between us that would guide us?
That's a question.
Jason, you want to try that? Want me to try it?
Could you repeat it again? I'm sorry, I didn't get the question.
Sure. So my brother is deceased. My sister-in-law and I own a parcel on which a family business had been operated. How do I first deal with a recalcitrant in-law when we have no written agreements between us that would guide us?
Well, that's what FOR's all about. You're gonna come to us, and first we're going to see how the property was owned. But you're going to have to work with your recalcitrant in-law for sure. You're going to have to figure out Well, certainly, I guess who is the heir of that property since your brother died? I think what we're saying here is that they're both heirs.
And that's where the will, so we would have to look at the will and see legally where does title pass. Has the estate gone through probate? Is the probate process still in progress? And then at the end of that, once all the tax determinations are made and the property gets released, then the title is going to pass to the rightful owner. And this is why earlier we talked about having those buy-sell agreements in place, because it avoids a lot of those family feuds. Absent a buy-sell agreement, it's going to pass through either a will, or if someone dies without a will, it's going to pass through New Jersey's laws of intestacy, which are even more ridiculous and costly and creates undue friction and publicity. So, we'd have to go step by step. Where's the title of the property? Is the estate settled? Where does the property title pass? And has the tax, and mortgages and so forth been satisfied? And then at that point, it's a matter of negotiating.
The other question that comes up, I guess, in that question is you have to determine the goals and objectives of each party. I believe, Ted, your question talked about an operating business, and so the assumption becomes, is the operating business going to continue to operate, or is it going to close down? The two cousins may have a different opinion on that, or the person and the sister-in-law in the example. So it really is a detailed analysis, not only of the legal ramifications, but the operating business ramifications, and then the real estate implications. Are they going to sell the business, keep the real estate? Are they going to sell the business and the real estate? Is one going to buy out the other to operate the business? Do they neither one of them want to operate the business but want to own the real estate? So it's a very complicated question to which there's no simple answer.
Yeah, and if the person who asked the question, if they would like some more guidance offline, certainly feel welcome to reach out to any three of us, and we can provide you with some counsel.
Cool. So our next question comes from Steve, who asks, what are the new regs for individuals and businesses?
Yeah, when you say regs, I'm not quite sure if that means tax rates. Certainly, under the new tax law, everything's been revamped. There's a new tax table for 2018 and beyond, where generally the highest bracket went from 39.6 down to 37%. However, and this has gotten a lot of publicity in the press in New Jersey, and oh my aching back, the SALT state and local tax deduction has been limited to $10,000. As I mentioned earlier, the regs in terms of tax law, the brackets for corporations have come down significantly from the maximum C Corp bracket of 35% down to now 21% or even lower, depending on your taxable income. And for pass-through entities, LLCs and S corporations, there's now a new 20% qualified business interest deduction, which allows certain businesses to take a deduction up to 20% of their income. But believe me, it is a complex web of, greater than this, less that, if then, and something that we'd have to sit down and look at your specific tax situation. But overall, for New Jersey businesses, I think it's a tremendous positive. And I think that most businesses are going to be relieved come tax time this year. And there is some planning involved. For example, to get the 20% qualified business interest deduction, it doesn't just happen. There's some things that can be, managed in the way of payroll and other expenses that can best position you to qualify for the most of that 20% deduction.
Debbie asks, I already planned my estate a few years ago with my attorney. Why would I need to do it all over again?
Yeah, I'll take that one quickly. Jason talked about fluid versus static when he sort of teed up our presentation today. Tax laws are always fluid. And the best laid plans that were done just a couple of years ago may now in many respects be obsolete. And we strongly urge everyone to revisit their estate as well as their corporate and personal income tax plans to make sure that they're taking advantage of the increased exemptions for gift and estate and generation skipping purposes, and also taking advantage of the income tax provisions that have appeared in the law. And as I mentioned earlier, it's important to do it sooner rather than later so that you can position yourself to take advantage of these things, particularly since there is a ticking clock and these provisions will go away in 8 years, if not sooner. So it's very important to review, dust off those documents, and take a fresh look.
All right, well, that looks like all the questions we have, and it's 12 o'clock anyway, so I think that's a good time as any to bring this to a close. Don't forget, all of you will be receiving a recording of today's webinar and the PowerPoint slides via email. Lastly, when you close out of the webinar, a survey will come up on your screen that we hope you'll fill out so we can understand how to best provide you important information in a webinar format. Our next webinar, 3D Printing, a Supply Chain Revolution, will take place Wednesday, May 30th. So by all means, feel free to register for that one right on our homepage, and we'll see you there. So until next time, for Jason Sobel, George Jacobs, and Dan Prashada, this is Vinny Civitello, thanking you for being with us this morning and wishing you a great day.